and today I will discuss the kinds of dower and other aspects of the dower. Ladies and gentlemen, dower under Muslim law is classified having regard to the mode of the payment into two classes or categories. One of them is called as specified dower and other is known as unspecified dower. Now the point is what is the specified dower? In fact, specified dower is the dower which is fixed or specified at the time of solemnization of marriage by mutual agreement between the parties. For example, A proposes to marry with W, and at the time of formation of the marriage or at the time of nikah ceremony, A and W with their mutual free consent makes the agreement or decide what will be the amount of dower in respect of their marriage which is going to be solemnized. So whatever amount of the dower will be specified or will be fixed or will be determined either before the marriage or at the time of the performance of nikah ceremony or marriage, that amount will be known or is known as specified dower. Very simple, that when parties with their mutual consent agreement settle what will be the amount of the dower which will be paid by the husband to his wife on the marriage or after the marriage, that determined or settled or fixed amount of the dower is known as specified dower. Specified dower is further divided into two categories. One of them is called as prompt dower and the other is called as deferred dower. In Urdu, the prompt dower is known as Mehr Muwajjal and deferred dower is known as Mehr Muwajjal. These are the Arabic words used in place of prompt and deferred. Anyhow, as a general principle, uh, specified dower is classified or divided into two categories. One of them is called as prompt dower and other is called as deferred dower. Again, the point is what is the prompt dower? Prompt dower means portion or part of specified dower or fixed dower which is payable promptly or immediately on the demand of the wife. Therefore, whatever part or portion of the specified dower is made payable by the mutual agreement of the parties promptly on the demand of the wife, that portion of the dower of that portion of the specified dower is known as a prompt dower. Prompt here simply means payable immediately on the demand or on the request of the wife. For example, A has married with the W and the amount of the dower was specified at the time of the marriage or before the marriage. Say for example, the amount of the dower, specified amount of the dower or fixed dower is rupees 1 lakh. At the same time, it is also agreed between the parties. There is an agreement or consensus between the parties, that is A and W, because they are the parties to the marriage. and it is finally decided that out of a fixed amount of the dower, for example, out of rupees 1 lakh, which is the specified dower, out of 1 lakh, 40,000 will be prompt dower. So this 40,000 will be paid by the husband as and when there is a demand from the wife, meaning thereby that this amount of the dower is to be paid by the husband immediately after the marriage on the demand of wife, preferably before the consummation of the marriage. Therefore, prompt dower should be demanded by the wife before the consummation of the marriage, and if it is demanded by the wife, then husband will be under the obligation, he will be under the legal obligation to make the necessary arrangement for the payment of the prompt portion of the dower. In case the husband fails to pay the prompt portion of the dower to his wife, then some legal consequences will follow from it. And one of the legal consequences that follows from the non-payment of the prompt dower on the demand of the wife is that wife can deny cohabitation with the husband, means the husband can be denied the access, or wife can deny the sexual access to the husband. This is one of the internal or in-house remedy that is available to a wife in the event of non-payment of the prompt portion of the dower on the demand of the wife, that husband can be deprived of cohabitation or access by the wife, though he may be legally entitled to it. So, this is the example of prompt dower, that is portion of the specified dower which is to be paid by the husband promptly on the demand of the wife. That portion is known as prompt dower. When mode of the dower is not specified clearly at the time of fixing the amount of the dower, because sometime it may happens that parties have fixed the dower. Say for example, the fixed dower is rupees 1 lakh in a given case, but it is not mentioned what portion will be prompt and what portion will be deferred dower. Then, as a general principle of law, entire amount of the dower shall be treated or will be regarded as prompt dower, and on the demand of the wife, husband will have to make the necessary arrangement for the payment of the entire amount of the dower, which by operation of the law will be deemed to be prompt. But if it is split into two parts, one part is made as prompt and other part is made deferred, then only the part of the specified dower which is made or mentioned as prompt, only that will be required to be paid by the husband to his wife on her demand immediately after the marriage. Now, the next and important point for consideration is what is the deferred dower, because I have already pointed out that dower is can be classified into two broader categories. One is prompt and other is deferred. What is the prompt? I have tried to explain with the help of the example, and now I am trying to explain what is the deferred dower, or what is the meaning of this category of the dower. Deferred dower is that which is payable in future, means it is just opposite to the prompt. Prompt is payable on the demand, immediately on the demand of the wife. Deferred means it is postponed for payment in future. Therefore, it may be payable in future on the dissolution of marriage by death or divorce. Deferred dower is also known as Muwajjal, and it refers to a dower that is not immediately payable after the before the consummation of the marriage. Rather, it becomes due only upon the occurrence of a specified event, or that is expiration of particular period or dissolution of marriage through the death or divorce. So, very simple and very clear that deferred dower means the part or portion of a specified dower, the payment of which is postponed for future on the happening of the future event. And what is the future event? That is that it will become payable on the dissolution of the marriage due to the death of the husband, or on the dissolution of the marriage when the divorce has been given by the husband to his wife. So, in either case, if the bond of the marriage comes to an end due to the death of husband or due to the divorce by the husband, in both the situation, in both the cases, the deferred dower become due and payable by the husband to the wife. Now, the very simple, very natural question, that if marriage is dissolved by death of the husband, then who will pay the deferred amount of the dower? From whom the deferred amount of the dower will be recoverable by the widow of the deceased husband. This because I have just pointed out that deferred dower becomes payable only on the dissolution of marriage by death of the husband or by divorce. So, now if there is a death of the husband and certain part of the specified dower is mentioned as a deferred dower, then this will become payable will become due only on the death of the husband. So, now if there is a death of the husband, then this part of the dower can be recovered by the widow from the properties or wealth left behind by the husband. This is the personal obligation imposed by law on the husband, and therefore, being personal in nature, it will be recoverable from the personal properties which which are left over after the death of the husband. Therefore, this is a sort of the legal charge on the property of the deceased, unsecured debt running over the property of the deceased, and therefore, in the event of the death, deferred dower can be recovered by the widow from the property left by the husband. If there is a dissolution of marriage, husband has given divorce to his wife, in that very event, of course, since it is a personal obligation of the husband, therefore, husband is personally liable to the extent of entire amount of deferred dower, and the wife can recover it from the husband. In case husband fails to pay it, then she can file a suit, and a decree can be passed by the court, and it can be executed against the husband by attachment and sale of the properties in the name of the husband who has given the divorce. So, it becomes the payable only on the dissolution of the marriage that may be take place by the death of the husband or by the uh, divorce or talaq which is given by the husband. In Mirza Badr versus Mirza Khurram 1873, Privy Council has held that when parties have not stipulated as to which part of the dower is prompt and which part of the dower is deferred, then the whole amount of the dower will be considered as prompt, uh, whereas Sunnis, there is a division of the opinion on this point among the Sunnis, and Sunni holds that a half portion of the prompt dower, half portion of the specified dower will be prompt, and half portion of the specified dower will be uh, deferred. Now, the unspecified dower, uh, this is the other category of dower, that is unspecified dower. Here, unspecified dower means the amount of the dower, when the amount of the dower at the time of the formation of the marriage is not settled, is not determined, is not decided by the parties, then this type of the dower is known as unspecified dower. I have already explained that at the time of the marriage, normally the dower is settled, is decided by the parties with their mutual consent. When it is decided, it is known as specified, fixed dower, determined dower. When at the time of the marriage, parties fails to take a decision what will be the amount of the dower in context of their marriage or in their marriage, and marriage has been solemnized without fixing the amount of the dower, then such type of the dower is known as unspecified dower, whereas the marriage will be valid, because where marriage has taken place without fixing the dower, the marriage will be valid, it will be irregular, it will be simply irregular, and the amount of the dower can be specified later on at any later stage after the marriage. Therefore, proper dower which is determined on the basis of analogy having regard to where the settle upon which is settled upon her other female members of the father's family, such as father's sister, her own sister, and her first cousin, then such amount of the dower is known as unspecified dower. However, the criteria for determining the proper dower is the social position of the women's family, wealth of the husband, the wife's personal qualification, the circumstances or the time and condition of the society, and the husband's status. This is very simple formula that in case the dower was not specified at the time of the marriage and marriage has taken place without mention of the amount of the dower, and it is required to be settled later on by the parties, then parties can specify or can fix the amount of the dower even after the formation of their union of the marriage. How the unspecified dower will be specified, what formula will be applied, what factors will be taken into consideration for determining what should be the amount of the dower in the given circumstance, or the basic and fundamental rule is that unspecified or proper dower will be determined having regard to the first, the status of the wife, that includes education, virtues, beauty, and some other good habits of the wife. Vis-a-vis the amount of the dower which has been settled upon or which has been fixed in the case of the marriages of her own sister, sister of her own brother, sister of her own father, as well as uh, her own first cousin. So whatever amount of the dower was fixed in the marriage of her own sister, her own cousin, her in the marriage of the father's sister, that amount can be fixed in a given case. So this is the basic criteria. This is the fundamental rule regarding how the uh, unspecified dower will be made fixed or will be determined or will be specified. The formula is loud and clear. Now the next point for discussion uh, in relation to the topic of the dower is what should be the amount of the dower in a given circumstance or in a marriage. So far as the Muslim law is concerned, Muslim law does not prescribe any formula, or there is no hard and fast rule providing for the specification of the amount of the dower. Means the fundamental sources of the Muslim law does not give any formula or rule as to what should be the amount of the dower. It is to be decided by the parties to the marriage according to their own financial condition, social status, their wealth, their personal qualification, and condition of the human society in which they are putting up or living. Therefore, no hard and fast rule has been specified by the Holy Quran as to what should be the quantum or amount of the dower. Again, it has been left to the wisdom and discretion of the parties concerned, and they should decide the amount of the dower according to their own means available with them, particularly according to the means available at the disposal of the husband. If the husband is economically very poor person, having very meager financial resources, then amount of the dower may be fixed according to his financial condition. But at the same time, if the husband is very wealthy person, his earning is very high, he is a well-to-do person of his family or society, then having regard to his financial resources, financial condition, the amount of the dower should be fixed, and the amount of the dower of a poor person, amount of the dower in case of a wealthy husband should be different, because it is subject to the attending financial facts and circumstances. And therefore, Holy Quran, which is the fundamental source of Muslim law, that clearly provides, simply lays down the guidelines how to fix, how to decide the amount of the dower or quantum of the amount of the, how to decide the quantum of the dower. Whether the quantum of the dower should be rupees 50,000 in a given marriage, it should be 1 lakh in a given situation, it should be 20,000 in a given situation, or it should be just a very meager amount in a given case. So now how to decide this? The Holy Quran guides on this matter, and the guidance of the Holy Quran on this matter is very loud and clear, and it provides that wealthy should decide according to his means, and the poor should decide according to his own financial resources. So it is the financial resources available at the disposal of the husband concerned that must be taken into consideration while determining the quantum or amount of the dower. Therefore, Islam has left it, fundamental sources have left it to the discretion and wisdom of the party. But care must be taken of the fact that while deciding the quantum or amount of the dower, parties must be very judicious. Husband should be judicious, his approach should be judicious. At the same time, wife must also be careful about the financial and social condition of the husband, and taking into consideration these factors, the amount of the dower should be decided. Whereas the Hanfi and Safi jurists hold that lowest amount of the dower should not be less than 10 dirham or any sub-object of equal value. But Imam Malik, the founder of the Maliki school, is of the considered opinion that the lowest amount for the dower is maybe 3 dirhams or should be the 3 dirham, and according to some other jurists, it should be not less than 5 dirham. So according to the Hanfis, the minimum amount of the dower should be 10 dirhams. According to the Malikis, it should be 3 dirhams. But in Hanfila, the lowest amount of the dower has been indicated that it should be 10 dirham or not less than 10 dirham. But its maximum limit has not been indicated or prescribed by the Hanfi school. Again, it has been left open-ended for the parties, because what can be the possible amount of the dower, that can be decided taking into consideration financial and social condition of the husband as well as of the wife. Therefore, Hanfis and Malkis, they have indicated as to what can be the minimum amount of the dower, but they have not fixed any maximum limit of the dower. However, in Shia law, even the lowest amount of the dower has not been fixed. But Shia holds that maximum amount of the dower should not be more than what was fixed in the marriage of the daughter of Holy Prophet, that is Hazrat Fatima. And as per literature available on the subject of the dower, of 500 dirham was fixed as a dower in the marriage of daughter of the Holy Prophet, that is Fatima, Hazrat Fatima. Therefore, Shia school holds that since the marriage of Hazrat Fatima can be taken as a role model, it can be taken as a role model. Therefore, what should be the amount of the dower, that should be based on the amount of the dower fixed in the case of the marriage of Hazrat Fatima. And since in case of Hazrat Fatima it was 500 dirham, therefore it should not exceed the limit of 500. But Shia school does not prescribe any minimum limit as has been prescribed in case of Hanfis and Malikis. Now the next point for discussion is subject matter of the dower. Subject matter of the dower may be anything that exists in the form of money, property, or any valuable security. Means anything which has value in the market, that can be the, as a general principle, that can be the subject matter of the dower. It may be a ring, uh, maybe of gold or maybe of silver, maybe handful dates, pairs of the shoes, teaching Quran to the wife, husband services rendered to the guardian of a minor, uh, etc. If the marriage is consummated and is dissolved by the death, then whole of the specified dower in case of regular marriage, proper dower if unspecified in case of irregular marriage, and specified dower or proper dower whichever less in case of irregular marriage will be payable on the death or dissolution of the regular marriage. If marriage is not consummated and is dissolved by the act of the parties, that is by divorce, then half of the specified dower will be payable in case of regular marriage. If the amount of the dower was unspecified, then only presentation of the 3 articles will be suffice in case of regular marriage. And when divorce by the wife, wife is given the divorce and the amount of the dower was not specified, then she will be entitled only to the something in the form of 3 items. But when divorce has taken place without the consummation of the wife or marriage and no amount of the dower was fixed, then no the dower will be due to the divorcee, or will be entitled, the divorcee will be entitled to any such amount of the dower. So this is all about the dower, that what is the dower, what is the nature of dower under Muslim law in context of nikah, and then nature of the dower I have already discussed with reference to the fundamental sources as well as the decision by the Privy Council as well as the various high courts. And I have also discussed that is kinds of the dower or classification of the dower in detailed way. And then I have discussed as to what can be the possible amount of the dower and how the amount of the dower will be paid, and what will be the condition wherein the entire amount of the dower will be payable to the wife in the event of dissolution of the marriage by the death of the husband or by the divorce. Where marriage is irregular marriage, amount of the dower has not been specified, marriage has not been consummated, divorce has taken place, then what will be the amount of the dower payable to the wife or divorcee or widow. So all these points I have already taken up and discussed in detail. Next time, or in my next lecture, I will try to explain some other points connected to the topic of dower. Thank you very much.